Today we have Dr. Ragini Kobalkar, Associate Professor at Maharashtra National Law University, Nagpur. She is attached with MNLU since 2016, and she has immense interest in the study of finer aspects of intellectual property laws. She has done her PhD on protection of copyright law, national and international perspective. She has attended various conferences and seminars and presented papers, especially on the topic of IP laws. Dr. Ragini has also got to her credit many honors and achievements, being the organizer and coordinator of national seminar, workshop, conferences, webinars, and legal aid programs on contemporary legal issues related to gender law and IP laws. She has worked as convener, member of coordination committee for WIPO, India Summer School 2017 to 2019. She has published various research articles in national journals and contributed chapters in books related in the area of IP laws and gender justice issues, published by reputed publishers. At MNLU Nagpur, she is in charge of Center for Intellectual Property Rights and chairperson of ICC of the university. Today, ma'am will speak on the topic digital research, ethics, and standards. So over to you, ma'am, and thank you for joining for today's session.
Thank you, Padma. Thank you, Navjyoti. Sorry. First of all, I extend my heartfelt thanks to Dr. Payal ma'am for inviting me and giving me chance to interact with PhD scholars. So thank you, ma'am.
Thank you, madam. Thank you so much.
Yes. Ma'am, these are all PhD scholars, right?
Yes, madam. They are all newly registered PhD scholar, and this is their pre-PhD coursework. So some of them have their topics with them, but some of them are yet to choose their topic. So these type of lectures may help them in finalizing their topic.
Okay, fine. Definitely. So the topic which I was given to me is digital research ethics and standards. So I just want to share my PPT with you. So yes, in this case, when I'm showing you PPT, I will not be in a position to see all of you. Only few faces I can see. Okay, and if you have anything to say, please do one thing. You unmute yourself and ask questions. Okay, whenever you feel. So that is not an issue for me. It should be more interactive. So I'm saying that you can ask any questions and at any point of time. Yes, I'm making it. Yes, ma'am, my PPT is visible to you.
Yes, madam.
Yes, madam. Yes, thank you. So, see, when we are talking about digital research, ethics and standard, that is what we have to consider over here. And when we are talking about research ethics and standards, definitely the law which is in place, the regulations which are in place, we have to refer to that. That's why I have written here specifically that UGC, University Grant Commission's promotion of academic integrity and prevention of plagiarism in higher educational institution regulation 2018. Okay, because when we are talking about writing something on our own, it is very much required that we should know what are the set of rules and regulations which are in place and which are going to regulate our writing. Okay, so these are the regulations which has been framed by UGC. But apart from that, to some extent, we should have some understanding about copyright law also. So with that perspective, I am taking you first to copyright law, and then I will be dealing with this regulation of 2018. See, copyright law, why I am discussing? Because when you are creating something, okay, you can say that you have right over that creation. very commonly known to everyone. So when we are saying that I have created something, so I will be having right over that particular creation, it means that nobody else should copy that particular thing and use it by or with his or her name. That is what copyright, that is what the core gist of copyright is. Okay, with that note, I'm starting with it. Okay, so we have seen that with the digitization, it is very easy to transfer the data from one end to other end, and throughout the world it can be possible. So fastest means of communication is technology, which has been started in the last decade of 20th century, I can say, but it comes to India in the 21st century itself. And we have seen that whenever we are writing something, it's very easy to upload something on the website or download something on the website. And these things create confusion in our mind, in layman minds. He or she do not know that exactly when they are making mistake, whether the contents, when we are saying that it is available on the website, it means it is in public domain or not. What exactly it means, that we have to understand. Okay, and if we are not able to understand then it will be stated that plagiarism has been done by so and so. So what exactly plagiarism means? See, plagiarism means the appropriation of another person's work or another ideas, process, results, or words without giving appropriate credit. So credit is very important over here. Okay, we have to give attribution to the author, to the creator, that this works belongs to that particular person. If we are not doing that and making copy of it or using it without due authorization, then that will comes under the umbrella of plagiarism. See, we are not going to get any specific definition of plagiarism in the Copyright Act also. Okay, this we have to read out through various regulations, through commentaries and other things. Okay, so whenever we are doing copy paste, copy edit paste, there are different types of plagiarism which are prevailing in this particular area, like word switch plagiarism, metaphor plagiarism, idea plagiarism. Okay, then on the basis of degree or types of plagiarism, matchwork plagiarism, globe plagiarism, incremental plagiarism, post copy plagiarism, photocopy plagiarism, the self plagiarism. If you just go to internet and search out types of plagiarism, you will get all the information about this type of plagiarism. Okay, that is possible because sometimes we are in a hurry. Okay, we are in a hurry. We have to achieve certain goals, like PhD karna hai, you have to submit your um, synopsis within a period of time. You have to submit your paper within a stipulated period of time. At the same time, you have to do your duties at your workplace. You have to do your household work also. And with that all thing, what happened automatically, we tends towards copying something, writing it in your own words and saying that it's my variety. Okay, that is what happening. And it happens here. I have given some of the reasons. Paucity of time, easy access, internet ki wajah se you can, means you can find out some or other information on any topic, whichever you tries to find out. Okay, so easy access is provided. Then reaching deadline. Yes, Payal ma'am has given you deadline for submission of something and you do not have time on that day. Your university, your college principal also has given some deadline, some work. You have to attend conference. Many things are there. So that may be one of the reasons. Yes, anybody wants to say something? I'm not able to hear you, Ingole sir. If you are asking,
no, ma'am. It's okay. We can ask my questions, please.
Okay, okay, sir. So then the smartness in manipulating data. The young generation is really, I appreciate, they are very smart and I am learning from them. I should say that many things I am learning from them, because when you are in this profession, we have to remember the one thing, that we should always be learners. If we have that tendency, then it will definitely help us in teaching, in fulfilling our dreams in this world. Okay, because the pace with which these young minds are doing everything, we should learn to some extent. That is also required. Okay, then assignment feel overwhelming. Okay, and paucity of time. That is what, these are the some of the reasons in general. We see that these are the reasons which force us to do such things or copy certain things. Okay, that might happen. I'm not saying that everybody is doing this, but automatically or due to certain reason, we do this work. That interpretation of senseless work, pressure from family members, yes, then placement, ignorance of credibility, and lack of knowledge about plagiarism. That is also very important. And very aptly, this topic has been chosen, that when we are talking about copying something which is available digitally, then it will amount to plagiarism and when it will not. If that thing is clear in our mind, it will be very easy for you to complete your work. Sorry. So just because you are taking some contents from internet, it doesn't mean that you are correct. Because see, we have to understand one more thing. Okay, whenever we want something to upload, that is easily possible with this particular technology, I can say. Okay, and when I'm saying I am able to upload something, in the same manner, I am very easily download something which is important for me, which may be relevant for my work, so anything. So what happened in such things, we do not know how to utilize that particular work. If we have clear idea about utilizing that particular work, then our work, our writing, our research paper, our thesis, very easily, very smoothly, that will be done. Okay, so we have to remember, we have to understand the difference between when we are saying copyright one hand, when we are saying plagiarism, how to do it, whether it's contrary concept or it's a intermingled concept, that we have to understand. See, when we are saying copyright, it is based on different principles altogether. Okay, that we have to understand. Being a student of research, copyright, though it may not be your core subject, intellectual property may not be your core subject, but still it is mandatory to understand what amounts to copyright. Because if we are infringing somebody's copyright and using their work as our work, then plagiarism will be done, and that will land you in a big trouble. Okay, so it is needed that we should have some idea, certain things should be very clear in our mind, what amounts to public domain, how to use that word. If that is clear and we follow systematically all those things, then you can do wonders, and you will be in a position to submit your work on time. Okay, Section 51 of the Copyright Act actually defines infringement of copyright. That's why I told you plagiarism word is specifically not mentioned over here. Okay, that is a common word which has been used, and you can refer in a different regulations. Okay, so infringement of copyright. That is what they are saying, that without the permission of the creator of the work, if we are doing something with respect to the rights which has been given to the copyright owner, then that will amount to infringement of copyright. That is what it says. Now, what it means? Are all of you are from law background? Anybody please tell me?
Yes, madam. All are law students.
Law student. Okay, great. So you have idea about copyright then, right? Yes, great, great. So my
Yes.
job has been reduced. Okay. So you know that when we are talking about copyright, there are 6 subject matters only. If our creation with respect to those 6 subject matter, then it will be protected under the umbrella of copyright law. And here we are particularly talking about creative work, that is artistic work, which we are talking about, which we are taking help to write our thesis. And sometimes artistic work also will come into picture, because we are, while making PPTs, we are referring to certain images, like this image which has been taken from Google. Okay, so here I am sharing with you that the image is not mine. I have not drawn it, but it has been taken from the Google. And the other thing, the image, though it is available on internet, I'm using it for the purpose of research, for the purpose of education. So section 52 has given certain conditions also, that if you are using the work for fair dealing, and very precisely it says that if it comes under the purview of fair dealing, then that will be permissible. So if you are using the word for your research purpose, for education purpose, there is no need to inform or ask permission from the owner of that particular work, okay, unless and until that particular type of license to be taken. If it is Creative Commons, then we can use it. Okay. There is no need to ask them, because we are referring it for education purpose, and very precisely we have to give attribute also, that this work belongs to so and so. Like I am saying that this image is belongs to Google. It's not owned by me. Okay. So for education purpose, as well as attribution has also been given. Okay. So there will not be any infringement of copyright. Okay. So section 52 has given long list. Under certain circumstances, your action, your production, your performance, your publication, your recitation will not amount to infringement of copyright, and they are saying that it's come under the concept of fair dealing. Okay. Now fair dealings, that also we will talk about it later on. Okay. Yes. And Copyright Amendment Act in the year 2012 itself added two important provision with respect to digital right management. Okay, section 65A and 65B. That is also important provision which provide effective means for enforcing the rights of the owner in the digital age. Okay, so when we are trying to understand what are the rights available in case of digital economy, section 65A and 65B also supposed to be read out by all researchers. Okay. So, suggestion is that if we know there will be a copyright infringement, we do not copy and paste, give credit to mark direct quotation and use reference of citation and source. Use your own words and follow our conscience. Our conscience always tell us that what is right and what is wrong. We know that, but I told you, I share with you the reasons which force us to do plagiarism. But we have to remember that we are not supposed to do plagiarism at all. Okay. Now we have to understand work available on internet and work available on public. Yes, could you please help me out for this discussion to take forward? Is there any difference between work available on internet and work available in public domain?
Hello, ma'am.
Yes. Yes.
Yes, ma'am. If any work is available in public domain, it means that yeah, we can actually with giving the
You are not audible, ma'am.
May I give an example? When means even if we take an example of a legislation, when any piece of bill is tabled, that comes under the public domain, and unless it is tabled, till it is tabled, it will remain a mere document. If that document available, if it is available on the internet, we can say that is the work available on the internet. But when it available for the access for the general public, that becomes a public document, means that becomes a work available in public domain.
Okay. Okay. Any other explanation, please?
Madam,
Yes.
can it be
Yes.
that work available in public domain will not be protected by way of any intellectual property right? And if at all, if the work is available on the internet, we might see that it is protected by some kind of copyright or whatever. I mean, intellectual property
Very
right.
correct. Very correct. That is what. Thank you, Chetan sir.
Thank you.
That is what I was expecting. Okay, when we are saying work available in public domain, means nobody is claiming copyright in that, and that is very freely available to use it to all. Okay, but just because matter is available on internet, we cannot say that we can make use of it. Okay, public domains means after the expiry of the copyright period, or the copyright owner has stated that I do not have any objection to use my material. Okay, she is or he is saying that I'm waiving my copyright on the particular work. Then these are the two conditions when work will be only in public domain. Otherwise, it will be available to us as it is available in books, as means it is available in physical copy. Okay. Just a minute. May I start chat box also? Let me check. Chat. Yes, because many questions are coming through chat box. Okay, so this is clear. Internet and public domain, either copyright period, that protection is over, or the owner does not want to share, does not want to hold copyright at all on that particular creation. Okay. And the other question, what is self-plagiarism? Can I do further research, same research as done my LLM dissertation? Mumbai, my topic was comparative analysis. Review of law. Can I do further research on it, or it will come in umbrella of plagiarism? See, it depends. Okay, you can do the research on the same topic, but when it comes to your dissertation, your focus is very wide. Okay, and you will see that when you will read more and more about it, automatically your research questions, your research objectives, your hypothesis is going to be different. It will not limited to your dissertation. So you have to bring that difference in your synopsis of your synopsis of your thesis. Then only if RC committee convinced that you are going to bring it to at a different level altogether, then they may accept it. Okay, I cannot say that always they will accept it, but you have to demonstrate that what difference you are going to make into that. Then only that will be considered. Otherwise, it will not. And self-plagiarism is that when we are actually when we are using our own articles in our new articles, okay, copying same and putting it over there in that article and just giving reference to our own old article. That is self-plagiarism. Sometimes we may give, or sometimes we may feel that it's my article. Why I should give reference of that? And you copy that and put it paras one after another in your new article. Then definitely that amounts to self-plagiarism, and that is not permissible at all. Okay, you can use only the idea which you have conveyed in that particular article for your new article, and there you have to give your reference also, that this is the idea given by me or demonstrated by me in the earlier article, and to some extent that will be permissible. But continuously you are giving the reference of your articles only, that is also not possible. That is also not permissible. Then in that case, what you are doing, you are compiling your articles, taking out some of the part of it and making compilation of that part and putting it as if your new work has been done. That is also not permissible. That is also one of the plagiarism. Okay, so we should remember that whatever is available on internet, somebody has copyright on it, okay, and we are not supposed to use it. But at the same time, section 52 allow us to use that work which is available on the internet. Then we have to understand that for our dissertation purpose we can use it, of course, but the thing is that we have to attribute that, we have to give reference of the author, where the article has been published, everything should be mentioned, and whatever idea you have taken from that article, you have to write it in your own words, okay, and then you give reference of that interpretation of yours. The reference will be of that author from whom you have taken that particular idea to understand or to clear your concept with respect to that subject matter. Okay, that action, that activity we have to do. Then only we can avoid plagiarism. Okay. Yes, idea expression dichotomy. Okay, I will not be going into deep with all these case laws, because see, these case laws gives us understanding. When we are talking about facts, that is not a subject matter which can be claimed copyright by anyone. Okay, so but the expression of those ideas, okay, that is going to be protected. Like for example, I just give you over here that everybody can make serial on Ramayana, on Mahabharata. That is possible. So what is that? That idea is same, making serial on the Ramayana, for example. But when we are publishing it, when we are actually making it, it is going to be different. Different performances will be there that cannot be similar, right? That is what we have to understand. So idea are totally different thing. Idea may be same, but here what copyright is saying, the expression, the words in which the author has expressed his idea, those words, those same para, we are not supposed to copy it. At the same time, we have to remember that when it comes to facts, that cannot be a subject matter of facts per se, cannot be a subject matter of copyright. Okay, like I'm giving lecture in this platform, okay, digital platform. It's a fact, right? You are attending the lecture. One event is happening there. One accident happened there. These are all facts, and anybody can write on it, right? Anybody can talk about it and express it in different ways. See, when we are talking about copyright expression, here we are not talking about oral expression. Okay, we are talking about literary expression. That is what we have to understand. Literary, artistic, dramatic, or musical, cinematography, and sound recording. These are the 6 subject matter which are very precisely identified under Copyright Act of Section 13, which says that if our creation is with respect to these subject matter, then only you will be or I will be having copyright in that. Okay, so that we have to understand. And this is okay, I'm not going into that. The other thing, the principle, I'm just introducing you the principles on which copyright is based. Okay, so originality must be there. Okay, now when we are saying originality means what? Some new novelty? No, it is not so. When we are talking about copyright and originality particularly, it should be origin from that author, originated from me, originated from you. Okay, that is what we have to understand. Originating that expression by the author that has been expressed in some form, and those form very precisely talked about in these 6 subject matter. If that original expression is there, then that is going to be protected. In my class, I give this example to all my students that whenever we are writing paper, for example, answer sheet, see, one teacher is teaching you. Suppose that teacher gives you same PPT. That teacher is asking you to refer only one book, okay, for your examination. And that teacher is going to set single paper for all of us, right? In that case, when we are going to write the answers to those questions, what will happen? Whether similarity will be there? Is it possible? All answers are going to be same. Is it possible or not?
Yes, ma'am.
Yes, ma'am. Yes, yes.
Okay. So
There are
after the
limited chances,
lecture,
ma'am.
see, similar means no, similar no, identical I want to say, not similar. Identical रहेंगे क्या सारे के सारे आंसर? ये बताओ मुझे. Is it possible? No, no, Rajesh sir. If
No.
no,
मैडम
why I am
आइडेंटिकल
saying
नहीं लेकिन सिमिलर आ सकते हैं.
similar आ सकते हैं, identical नहीं आ सकते. That is what we have to understand. Okay, so
Yes,
when we are
yeah.
saying that it cannot be identical means the language which has been used by different students, that is going to be different. Sequence जो रहेगा, कोई ये point पहले लिखेगा, कोई वो point पहले लिखेगा, कोई different wordings में वो point explain करेंगे ना. So similarity means अगर 5 point है एक question के तो वो 5 point आएंगे, but not necessary कि that will be in similar sequence, that will be in exact words, because there we are going to write our own word, originality, which has been origin from that particular author, and copyright protects this originality. Okay, so novelty is not the criteria which is going to be seen when we are talking about copyright. We are seeing that original expression of that particular author. If that is there, copyright law automatically protect that work. Registration of it is not compulsory. Okay, this much is clear. So your answers are going to be different, not identical. In that way, I want to say, though you want to convey the same idea, but your expressions are going to be different. And that expression, that original expression of the author is protected under copyright law. Okay, and that has been considered in FIST publication case long back in 1993. Then this idea expression dichotomy has been discussed in R.J. Anand case also in India. Again, that is very important case where they say that when we are transferring some idea from literary work to cinematography work, then definitely different plots will be there, themes, directions, different clothes. Some part of it will be similar and some will be different. But just because theme is same, we cannot say that theme same होने से we cannot say that infringement of copyright is there. That is not. Okay. And there are number of case laws which talks about all these originality and creativity cases.
Madam,
Okay.
excuse me, madam.
Ah.
Make a previous line of that movie, name of movie, please. Hello, ma'am.
Yes. Which one, sir?
That movie, name of the movie slide, please. Unpad and
RJ Anand.
what is the
RJ
other
Anand
name?
case you are talking about.
RJ Anand case. RJ Anand case. Cinematography subject.
It's based on literary work. Okay. It's based on literary work. On the we do not have much time, so I am not going to discuss it at length. Okay, Hum Hindustani, that was the stage show was there. On the basis of that show, New Delhi film was made by the producer. That was the allegation made by the author. Okay, Hum Hindustani. Name of the book, name of stage show, dramatic work was there. Okay, and on the basis of that, film has been made. That was the contention of the plaintiff in that particular case. Okay, so just to remember the names, Hum Hindustani and New Delhi, I have put these images over here. But this is not the real image of that particular book at all. Okay, just to remember.
Yeah.
Yes.
Okay,
so
thank you.
that was the show which was shown, was demonstrated, dramatic work it was, and then the movie was also there on the same theme and plot. So they question over there what is the idea expression dichotomy and how to interpret that. So Supreme Court has very well considered it, and it says specifically that it might be possible that there can be no copyright in any idea, subject matter, themes, plots, historical or legendary facts. So if we are talking about it, then nobody can claim copyright over there. That is what discussed over there, and I have taken some certain important points from that. Okay.
Okay, thank you.
We have shortage of time. Okay. These are other cases which talks about creativity and idea expression dichotomy. Okay. Then work, I already talked about, which are the 6 subject matter on which copyright law we have to think about. Then what is protected under copyright law? Yes, whatever we are writing, that may be question paper. Like if I am framing question for you people, okay, that will also that on that also I will be having copyright, because that is my original expression. Okay, which I am putting forth in a literary form, and copyright says that once you express it, you will be having copyright. Okay, registration is not compulsory, but if you register, that is good, because we know that being a student of law, evidence agar hota hai, so that is good proof, good to prove before the court. Then thesis, dissertation, those who are writing it, they will be having copyright in that. Being a supervisor, I will not be having copyright in any thesis, any dissertation. The student who writes it, it belongs to him. Okay, so many things I have given example over here, that these are the things which are subject matter of copyright, and these are the case laws where this particular subject matter has been considered by the various courts. Okay. Then yes, then comes plagiarism regulations, okay, of 2018, which are very important and which should be known to all. See, whether it will be physical copying or whether it will be digital copying, means whatever available on internet or soft copies if available. General journals are available, many journals are available. So whatever we are doing, if we are copying somebody's work and showing it that we are owning it, or we have created, we have ownership on that particular work, then that will amounts to infringement of copyright, or that will be termed as plagiarism. Okay, and this has been stated in this regulation of 2018, UGC regulation of 2018, which says that academic assessment of academic and research work done leading to the partial fulfillment of the award of degree of master's and research level by a student or a faculty or a researcher or a staff in the form of thesis, dissertation, and publication of research paper, chapter in books, full-fledged books, and any other similar work reflects the extent to which elements of academic integrity and originality are observed in various relevant processes adopted by higher educational institution. So we are coming under this academic regulations also. That should be very clear in our mind. Okay, and it has talked about what amounts to academic integrity. See, it is not the thing that this regulation will be applicable only when we are doing physical copy. Okay, बहुत सारे books होते हैं library में, going to the library and copying paras after paras. That is not good. Okay, that is not permissible at all. In the same manner, when its books or material is available on internet, digitally the material is available at that time also, we are not supposed to copy it, or if we are referring it for the purpose of education, for the purpose of research, then we are coming under the umbrella of fair dealing. And fair dealing says that we have to give attributes that can be read out from regulations also. We have to say that. What's wrong in that? If we are giving recognition to that particular author, that if suppose I want to know what is plagiarism, for that matter, I am referring to 5 articles, right? If I am saying that from one article, my idea about plagiarism is clear, and as per that, I am writing what is the meaning of plagiarism in my own words, and then I am giving reference of that particular paper which helped me out to understand what is plagiarism. Then for types of plagiarism, I have referred some other article, and I understand that after referring 2-3 articles, I am in a position to identify what are the types of plagiarism. So after writing about types, after those writing, that is in my own words about the types, I'm mentioning over there, I'm giving reference that this is the idea, this is the work which I have taken from so and so author. So you have to write about the author, publisher, journal, or year. If link is there, that should be given. And when you visited to that particular link, that also very important to mention, because see, it is a platform. Okay, anybody can upload their work or withdraw their work. Okay, if I'm paying to upload my content for 6 months, Google is allowing me to put my work for 6 months. After 6 months, if I am not renewing my contract, that might be withdrawn. So if you are mentioning that you have visited on so and so date, at that particular time, that material is available over there. That gives authenticity to your work. That is what we have to understand. We have to give authenticity. See, if I am saying something without any reference of regulations, without any reference of law, copyright law, then how you say that just because I stated something, you will rely on that? No. What you will say that give ma'am some proof, whatever you are saying, where it has been written, how you are saying this. Okay. So that is what we have to understand. So authenticity comes from attributions, comes from reference, which we are using while writing our thesis. Okay. Yes. So here we can see some important definition I have placed over here, and this act is very much available on the website of UGC. So you can also refer it. Okay. Academic integrity. is the intellectual honesty in proposing, performing, and reporting any activity which leads to the creation of intellectual property. Okay, so while creating our thesis, while writing our thesis, dissertation, what we are doing? We are doing some intellectual activity, creating some intellectual property. आपके PhD thesis शोध गंगा पे रहेंगे ना available. Okay, so that is what your intellectual property, and nobody should copy it. For that matter, you are putting it on Shodh Ganga. It is not for the matter that somebody may copy it. In that case, turn it in Pakad Lega. Okay, now the good softwares are there which help you to identify the plagiarism also. Okay, to some extent, it is permissible. Okay, but to what extent? That also we should understand. Austin ki theory, yaad hai na, whenever we are saying that sanction is there, automatically everybody tries to follow it. If sanction is not there, then nobody follows it. And that is what understand by the UGC, and they have come up with this regulation of promotion of academic integrity and prevention of plagiarism in higher educational institutions. Then they have talked about departmental academic integrity panel. See, whenever our institution is involved in any academic activity, any research activity, it is mandated that we should have departmental and academic integrity panel. Because if some complaint has arrived, some plagiarism has been done by somebody, if student wants to raise complaint against his teacher, against his supervisor, because such types of cases are coming forward. Okay, some students are saying that whatever projects they are writing, whatever research paper they are writing and submitting to the teachers, they are publishing those papers on their own names. What is this? Where we are taking to this noble profession? Okay, so academic integrity is very important, and to protect that, this regulation has been introduced, and they say that we should have departmental academic integrity panel. Just a minute. Yes. Then they also talks about institutional academic integrity panel. Nowadays, many colleges, many universities are autonomous, and you have different departments. So for each department, departmental academic integrity panel should be there, as well as on the basis of institution, big institution, you have institutional academic integrity panel should be there whenever some complaints with respect to plagiarism comes. So here you can see the definition of plagiarism. Okay, it is not there in the Copyright Act. Plagiarism means the practice of taking someone else's work or ideas and passing them as one's own. Now here also you can see that the word which has been used in this regulation is ideas. That is not, if we go by Act, it says that ideas cannot be protected, but expression to be protected. But as it is regulation which has been close or which has connection with copyright law, we cannot read independently regulations. We know that being a student of law, we have to see all the things, pari materia, whatever subject matter, on the same subject matter, whatever laws, regulations are available, we have to refer to that. Okay, so idea here, though that words has been used, but we have to remember that they are talking about expression of that particular person. Is the practice as one's own. That amounts to plagiarism. Okay. They talks about script also. Script may be research paper, thesis, dissertation, chapter in book, or full-fledged books, or any other similar work submitted for assessment, opinion, leading to the award of master and research level degree, or publication in print or electronic media, by student or faculty or researcher or staff on of an higher education institution. However, this shall exclude assignment, term paper, project, coursework, essay, and answer script. These are not the subject matter to which we can apply this regulation. Okay, that is not so. Yes, so similarity will check and they will decide that plagiarism, how much plagiarism to be avoided. The regulation has very precisely stated what should be, what should not be evaluated while doing the plagiarism check. Okay, all quoted work reproduced with all necessary permission that should or attribution. See over here also you can see the reflection of Copyright Act. It says that if attribution is there, no need. All references, bibliography, table of content, preface, and acknowledgement. That is also permissible. Okay, that is also excluded. All generic terms, laws, standard symbol, and standard equation should be excluded while checking the plagiarism. That is what very precisely provided in the regulation itself. Then they have given level of plagiarism. If you are putting your work in Turnitin or in any other software which can identify plagiarism, then if it comes to similarity comes from 0 to 10%, it will be treated as minor similarity and no penalty will be there. In case of level 1, 10 to 40% similarity, that is they are treating at level 1, and level 2 similarity above 40 to 60, that is second level, and third level similarity about 60. Now by creating this particular label, what they are trying to see that they are trying to identify the work which should not be evaluated or which should be rejected or for which punishment to be considered. So when we are talking about level 0, 10%, 0 to 10, that much similarity is going to happen. So there is no punishment for that. But when it comes to similarity about 10% to 40%, that is level 1. For that matter, they say that you may ask to submit revised script within a period of 6 stipulated time, but it should not increase to 6 months. Okay, for level 2, that is where similarity is from 40% to 60%. If our similarity is coming under these gap, then such student shall be debarred from submitting a revised script for a period of 1 year. Then level 3, similarity above 60%, such student registration for that program shall be cancelled. Okay, so you can see that what is stringent punishment is there in case of plagiarism. Okay, so we have to understand it in that manner that if somebody, some student is doing such thing, what will be the repercussion? That should be clear to all. Okay, then penalties in case of plagiarism in academic or research publication. Okay, for 10%, no penalty. From 10 to 40, we can ask to withdraw that manuscript. Similarity above 40 to 60% shall be asked to withdraw manuscript, shall be denied a right to 1 annual increment. If it is with respect to teachers, okay, shall not be allowed to be a supervisor to any master, MPhil, PhD student or scholar for a period of 2 years. Okay, we will be debarred for 2 years if we are making some plagiarism. Okay, and that is coming in between 40 to 60%. Level 3rd is that similarity where more than 60 paper is there. Then they will ask to withdraw, then shall be denied a right to 2 successive annual increment and shall not be allowed to be supervisors to any new master's program, MPhil, PhD scholar for a period of 3 years. So you can see that the punishment is very stringent when it comes to plagiarism, and we have to understand it, we have to follow it, we have to follow it, and we have to inform to our students also that what are the norms or principles which we are supposed to follow, which everyone's supposed to follow, just because everything is available. Nowadays, not physically we are talking, we are saying that we are copying from book, but we are copying from internet. So this should be very clear that when we are talking about material available on internet, it doesn't mean that it is in public domain. It is somebody's work which has been placed on that digital platform, and without their permission, we are allowed to use it when we are doing our research work, when we are doing our education, using it for educational purpose. Those are the exceptionals which we are allowed. But with those exceptional also, we have to write down or give the reference that from whom we are taking this work, from which journal, where we have visited. All those things should be very clearly mentioned. Okay. So, yes, misconduct in ethics, that is so there. Okay. So there are so many ethical codes are available in out of India. Okay. But I'm not going into this because this is not the topic which we want to discuss. But see, in some of the countries, they have gone beyond this regulation, and they follows that when it comes to ethics and somebody is doing misconduct with respect to ethics, then what can be done and what are the norms we are supposed to follow, that is their publication ethics. Okay, I think my time is over, so I'm stopping over here, and I want to take your questions. Okay, if you want to ask some questions, you can ask for it, because our area was with respect to digital references. Okay, so I'm not going on publication ethics and other things. Okay. Yes, please, you can unmute yourself and ask your questions.
I would request all the participants to please post your questions in the chat box. Ma'am, 2 people have put their questions. Shall I read with your permission?
Okay, I can read.
Okay, okay.
Ma'am, then what is about government published document wherein instructions or guidelines are mentioned? Okay, Pragati. Pragati, can you unmute and clarify more about the question?
Ma'am, can we say when will we copy this or send by PDF to others, instruction or guideline? Is it come under the copyright, or is it granted?
Yes, see, one more, remember one thing, that when it comes to legislation, rules and regulation made by the government, we have to remember that they have copyright. Government is having copyright on that work. Okay, just because they are publishing it. Okay, it is for giving knowledge to the public at large. But when it is in public domain in the sense that we can use it for research purpose. Okay, at that point of time, we have to refer that this is the rule of section of so and so act. That is sufficient. Okay, it will be in public domain. We can refer it. But it's not even we never republish any rules and regulation and saying that it's our rules and regulation. That is not possible. Miss, that is known to everyone. Okay.
Thank you, ma'am. Ma'am,
second question.
Madam,
Yes,
excuse me. Madam?
Yes, sir.
Ma'am, to what extent self-plagiarism is acceptable, ma'am? Self-plagiarism.
See, again, we have to follow the rules and regulation which has been mentioned in UGC's regulation. Okay. Self-plagiarism, to what extent I have clarified that if you are taking 1 or 2 references, just to say that your idea which you are proposing in this particular new paper, it is based on that particular paper, and you are taking it to further. Okay.
Okay.
Or some
Okay.
concept, clarifying some concept you are mentioning about, or you are referring to your own article. That much is permissible. Okay. But
Okay.
every para you are mentioning that refer my this article
No.
published by me in this journal, that journal. It means you are doing self-plagiarism. That is not
Okay.
possible. Okay. So exact
So,
percentage.
ma'am, miss, it is a kind of new addition in old work, isn't it?
Yes, that is possible. But the thing is that we have to remember exact percentage we never mention anywhere,
Okay.
neither in the Copyright Act nor in this regulation also. Okay, these regulations are about percentage of similarity. Okay, when we are copying somebody's work and that is very similar in nature, word to word. Okay, we are talking about regulation there. But when we are talking about copyright, there also we have to restrict ourselves. Okay, we are not supposed to repeat our things because there is no point. You have already have achieved the copyright in that your earlier work. Okay, so again, if you are writing or republishing that, that doesn't mean that you will be getting copywriting. Okay.
Got it.
Same words.
Thank you.
The next question is, when plagiarism is so important and it is the soul of research in every discipline, then why it is not defined in copyright law? You're valuable. Okay, Rajiv sir. Okay, see, yes, plagiarism is a general term. Okay, it is used in a common man's understanding. Okay, and when we are talking about any law, we are using their different jargon altogether. The words which has been written over there, those are with certain meaning, like infringement of our legal right. So infringement is very common when we are referring to any statute. Okay, and we know that whenever we are talking about this jargon, this has taken from Britishers. Okay, Copyright Act, which is also based on 1911's Britishers Copyright Act, which was they amended in 1914, and then we continued with the Act, and only certain amendments has been done. In the same manner, our complete legal system is taken from Britishers. So whatever words they have written over there in those laws, with the passage of time, with the precedents, they have achieved certain level of meaning. Okay. And we do not want to change that meaning. So whenever we are talking about legal rights, infringement is apt word to understand whenever there is a violation. So we started with that, and now when this technology has been with our hand, it's a common man's word, plagiarism. Okay. Yes. So in that angle, we have to understand. I hope I have given answer to your question.
Yeah. Thank you, ma'am. Thank you. Nice.
Sorry to intervene, ma'am. Our next resource person has joined. If students have any other question, then please mail to ma'am.
Yes.
On behalf of Postgraduate Teaching Department of Law, RTMNU, I would like to extend my heartfelt gratitude to our esteemed guest, Dr. Ragini Kulbarkar, ma'am, to share her expertise and knowledge on digital research, ethics, and standard. Thank you so much, ma'am. Very well explained and emphasis on copyright laws and plagiarism. Thank you so much. It was a very informative session.
Thank you, Navjot, ma'am. It's my pleasure.
Thank you, ma'am.